Thank you. And I will say, if you have questions, you can place those questions in the Q&A box, and we will be monitoring that throughout, but we'll most likely take them at the end of the presentation. There should be plenty of time for that. So what we wanted to do is we wanted to give you all a sense of how we got to where we are today. And so along those lines, it's important to keep in mind a policy that was in place before the current administration called the sensitive locations policy. This is a policy that was introduced, gosh, at least 20 years ago by the administration. And it's not part of the executive orders that you may have heard about in the news. What it is, it's a policy that says that the Immigration Service will not conduct enforcement activities in certain locations that are sensitive. And those locations that are listed, among those that are listed, these are the most common, are schools, sites of religious ceremonies such as weddings and funerals, sites of public demonstrations, think protests, think parades, hospitals and healthcare sites, and congregations or other places of worship. And so for many, many years, the Immigration Service, even during the first Trump administration, the Immigration Service has recognized that these locations are sensitive based on the nature of the activity that is conducted in those locations. And because of that, with very few exceptions, the Immigration Service would not conduct any enforcement activities in these locations. To fast forward to January 20th, when we had a flurry of executive orders signed by the current president, one of those executive orders said that they will use whatever means they have necessary to increase enforcement. So the executive order didn't specifically say, let's rescind this sensitive locations policy. However, a few days after January 20th, the acting secretary of the U.S. Department of Homeland Security issued a policy statement. And in that statement, he said that they would be rescinding the sensitive locations policy. And so one of the reasons why we're here today is because since that announcement, we have been getting a lot of calls and emails from concerned entities, a lot of nonprofit entities, because you could see that congregations, hospitals, and healthcare sites and schools are primarily nonprofit entities, on how to prepare for an event in which the Immigration Service will show up to conduct enforcement. So that's what we're going to talk about today. So, and that's why we're here today, because of the rescission of the sensitive locations policy. No, one of the things.
Can I just jump in really quick? One of the questions in the Q&A is whether homeless shelters are included on the list, and they're not. So they were never protected through the sensitive locations policy, and they would be in the same situation as other sites that were never and are not currently protected by the sensitive locations policy.
Thank you, Heidi. And thank you for monitoring that. So before we get into the logistics of preparation for a site visit, I do want to mention that there are some challenges to the rescission of the sensitive locations policy. And one of those is the Philadelphia Yearly Meeting of the Religious Society of Friends. These are our Quaker friends who have filed suit against the Department of Homeland Security, saying that such enforcement activities violates the First Amendment, which guarantees that the government would not intrude on an individual's ability to worship and to practice their religion. In this particular case that was filed in Maryland, the court did issue a preliminary injunction prohibiting enforcement activities, but it only applies to the plaintiffs in this case. So it's a very limited scope. There was another case that was filed in Washington, D.C. This is filed by a group of entities. It says Mennonite Church USA et al., but there are a lot of state church coalitions. state council, that's what I want, the state council of churches. There are a number of state councils of churches that have joined the Mennonite Church USA in filing a lawsuit against the Department of Homeland Security in the district court in DC. In this particular case, they asked for a similar preliminary injunction. That will be heard in April. We've been monitoring all of these cases, by the way, and this is the most recent update with all of them. Other than things like some attorneys have added their names to the representation, but in terms of the movement of the case, the Mennonite Church will be heard in April. And then last but not least, not a church, but the Denver Public Schools did file suit against the Department of Homeland Security in Colorado. And in that case, on March 7th, the court declined to issue a preliminary injunction. So we've got a range of decisions where the preliminary injunction was issued, limited, preliminary injunction was not issued, and then there's another case that we're keeping our eye on that should be heard in April. So it might be that the sensitive locations policy would be reinstated, but we just don't know that yet.
And that's not the case right now, right, John? Right now, the sensitive locations policy has been rescinded, and we should all operate under the assumption that there's not a good looking case for us to have a nationwide injunction right now.
Exactly.
Okay.
So let's talk a little bit about what a DHS or ICE raid is. And just to create the picture here, the Department of Homeland Security has within it many different agencies and many different immigration agencies. And one immigration agency is the Customs and Border Protection folks. Those are the people who are at the airports or at the land border who admit people. There's another arm of the Department of Homeland Security called USCIS, which is Citizenship and Immigration Services. That's the agency that adjudicates petitions and applications that are filed with the agency. And then the third arm is ICE, Immigration and Customs Enforcement. These are the folks who are likely to conduct the raids, but we may see other departments within other agencies within the Department of Homeland Security who might participate. So the word raid is used to refer to ICE agents primarily who go to a work site without notice as part of an investigation into an employer. It's really important to keep in mind that this is without notice. And we say this because there are other types of site visits conducted by the Department of Homeland Security where they do provide notice. And many of you may have heard about I-9 audits. And in some I-9 audits, the Department of Homeland Security would typically say, we are going to audit your I-9 records and we want you to send us copies of your I-9 records within the next, and then they give you a deadline or a number of days. And then they go through them and then they follow up, usually by mail, but sometimes they show up. And then there are other types of visits where they don't show up at all. And so this is what we're talking about, where they show up without notice. And that's why preparedness is so key. ICE raids typically target individuals and not employers, not entities, but individuals who they suspect are in the United States without authorization. So even though the target of the raid isn't the employer, it takes place at the employer's location. And that's why you're all here today. But generally, they're looking for people. Now,
and these people might also be people that your nonprofit serves. They might not be employees exclusively. So even if you're a nonprofit that doesn't have employees, to the extent that you serve people who are coming in and out of your location, this advice and our presentation applies equally to you.
Yeah, and it could be like the homeless shelter that was referenced earlier, or customers or patients. But you're right, they're not specifically employees. Sometimes ICE agents work alongside local police to conduct enforcement activities. We should mention that St. Paul and Minneapolis both have separation ordinances that prevent their local police from enforcing federal immigration laws. That's not always the case in some cities, in some counties, in some states, but at least in Minneapolis and St. Paul right now, there are separation ordinances. You may have heard the term sanctuary locations or sanctuary jurisdictions or sanctuary cities. That's what it refers to. When you hear of a jurisdiction that is a sanctuary jurisdiction, it means that that jurisdiction has taken steps to ensure that their local law enforcement are not cooperating or not conducting the enforcement activities that are really under the purview of the federal agencies. And there are some that do that, but Minneapolis, St. Paul specifically, don't do that. So I'm going to move it over to you now, Heidi, where we talk a little bit about the Fourth Amendment.
That sounds great. And maybe you can check out the chat while I'm doing that. So the Fourth Amendment of the United States Constitution protects all of us from unreasonable searches and seizures by the government, not by our friends or our parents, but by the government. And so ICE officers are required by the Fourth Amendment to engage only in reasonable searches and seizures. And to do that, they have to have a warrant based on probable cause that provides sufficient detail of the place to be searched and who and what may be seized. So we're going to talk now about searches by beginning with describing to you the difference between public areas and non-public areas. So the next slide there's a lot of words on this slide, but it's really important in thinking about the constitutionality of a search to distinguish between public areas and non-public areas. We've actually spent quite a bit of time helping our clients determine where in their space would be a public area and what in their space is not a public area. Because ICE agents, just like the general public, may be in a public area and they may enter it without a warrant and they may enter it without consent. So a public area is a place where there's not an expectation of privacy. Federal agents may enter those areas just like a member of the public without a warrant and without consent. They may also see things when they are in a public area that they don't have to have a warrant to see. They may overhear things in those areas, and they can ask questions of people in a public area without a warrant and without the need to receive consent. Public areas include areas in a public facility that the public can be in without being asked for an explanation or a reason for why they are there by whoever is in charge of the space. So they may, for example, include a dining area of a hospital, which you could go into if you worked nearby to the hospital and you wanted to use the dining room one day. They generally include lobbies if the door is unlocked. We have a few clients that have gone to locked lobbies, so that you can only get into the door of the facility if you buzz a buzzer and have a reason to be present in the facility. But if that's not true, if the public can open the front door and walk into the lobby would be a public space. Waiting areas where you can be without being asked what your reason is to be in the waiting area would be a public space. And outside parking lots and grounds, unless they are locked, are public areas and spaces. And in fact, some of the ICE enforcement efforts that we've seen in Minnesota have happened in parking lots and outside grounds. So ICE agents have the right, without a warrant, to be in a public area, and they have the right to see and talk to and learn what's in a public area without a warrant. Non-public or private areas, on the other hand, are those areas where there is an expectation of privacy. So they're areas where access is restricted. You have to have a reason to be in the area, or you will be asked for a reason to be allowed to be in that area. These spaces may include spaces that are not locked. So you don't have to have a locked door for a space to be non-public, but it has to be a space where you must have a reason to enter it and provide that reason to the person who's in charge of the space. So, you may have offices that are unlocked. Those are, but you have to have a reason to be there. Those would be non-public areas. Restricted waiting areas, like you have to go through a receptionist to get to a restricted waiting area, that would not be a public space. meeting rooms where you have to have a reason to be there, auditorium rooms where you have to have a reason to be there, respite areas where you need to check in with a receptionist to be allowed to access the respite areas. So in order to be in a non-public or private area of a private business or a public charity or your facility, an ICE agent must either have the consent of the facility or a judicial warrant. So from this slide forward, keep in mind, ICE agents have the right to be in public areas. They do not have the right to be in non-public or private areas.
Thank you, Heidi.
This is a repeat of what I just said. Federal agents may enter public areas. They can look at documents that are sitting on the counters in public areas. For example, a clinic may have at a reception desk, and on the reception desk may be a list of patients who are going to be seen that day. If that list is in clear view in a public space, the ICE agent does not need a search warrant to look at it and find out what's there. We don't prevent access to public areas. Agents are permitted to listen to conversations, take information they find there, question people, although individuals should know that they don't have they are not required to answer questions of ICE agents, but that doesn't mean that an ICE agent couldn't be in the public space and ask questions. In non-public or private areas, agents must either have consent or a judicial warrant to enter a non-public area. We recommend that non-public or private areas are marked so that everyone knows, and there's no question that going past this reception desk, this hallway, which looks like it leads straight from the reception desk, is a private space because you have to have a reason to be there. You'll be asked for a reason to be there. So that's the difference between public areas and non-public areas.
And I will add, if I could, that we'll be talking a little bit, well, we'll be talking quite a bit of detail about a judicial warrant and how that differs from other types of warrants. So as Heidi just mentioned, agents must have either the facility's consent, and we'll talk about consent, or a judicial warrant, and we'll talk about a judicial warrant in order to enter non-public areas. Just a little bit about preparation. Heidi, do you want to talk a little bit about site visit protocol preparation that entities can do, steps that employers or entities can take before a site visit actually happens?
Sure. So we think preparation for an ICE site visit is crucially important because while John is going to explain to you what a judicial warrant looks like, we don't think ICE agents are going to have a judicial warrant. The other way they can gain access to private spaces is through consent. And we don't want you to provide consent unknowingly or unwittingly or without understanding what you're doing. So part of what we're going to talk about next is preparing for a site visit. And to avoid accidentally providing an ICE agent consent to a private area, we think that these are good steps. First, designate a point person to talk to an agent. So you may have a receptionist at your facility. The receptionist, he or she can be instructed that in the event that an ICE agent appears, or it may be security, whoever's in charge of the open public area space of your facility should be directed to contact the person who's going to talk to the ICE agents. That should be the protocol. And whoever that is should be trained with respect to what to do next. But we think that the easiest and simplest thing to do is ensure that anyone who's the welcomer or the receiver of the public into a space understand that their role is to contact the right person within the organization who will interact with and ask the right questions of the ICE agent. So that's number one, designate a point person, make sure that those who are in the public spaces who are responsible for talking to people who initially come into your public spaces know who the point person is. Second, inform people, employees or people you serve of their rights. There are clear statements that you can get from nonprofit organizations, John, you can help me out here, that state exactly and in many languages what people can and should do if they are presented with questions from ICE agents. So have those cards available. John, they're called red cards.
They're called red cards. Yep. And you could literally Google red cards. And the agency that produces them, I believe, is the Immigrant Legal Rights Center. It's a national organization that focuses on ensuring that people, particularly non-immigrants, have access to their rights and information about what rights they have if they are detained. And they're available in multiple languages. You could order them, you could print them right from the website. But really, if you Google Know Your Rights card or Red card, you should find it pretty easily.
And in many languages.
In many
So,
languages. And I will
yeah.
also add that if it's helpful, you could reach out to us and we can provide you with a list of local immigration attorneys who represent individuals who need removal defense representation.
Haley just posted the link to the red cards. Thank you, Haley.
Thank you.
So basically, members, people who are in your facility can be informed of their rights. We don't think you should instruct people to refuse to speak to federal agents, but you can emphasize that they have the right to remain silent and not talk to ICE agents until they have spoken with an attorney. They may refuse to show identity documents. They can refuse to sign paperwork, and they can be provided with legal resources. And those red cards are really the best and easiest way to do that. So you can, download them and keep them at the front desk in the case that they may come in handy. You can also prepare guidelines for documenting an ICE raid. So we basically would like, if it is possible, for the person who's interacting with the ICE agent to record their name and to record their badge number and to ask them for a list of, or to record them if they have a phone available, and just to take down information about what they do and what they have seen them do while they're at the facility. So just taking notes. And then the last one there, clearly mark our private areas with signage. John, did you have anything to add on this one?
Only that we will, so these are, this is a protocol to prepare for a site visit. What a little bit further in the presentation, we'll talk a little bit about what to do during a site visit and then what to do after a site visit. So when you think about this, think about it in the fuller context as well. The only thing I will ask you, Heidi, is we have one more slide on consent. And then after we discuss consent, we'll go into the nitty-gritty of the types of warrants and what folks are likely to see during a raid.
Okay, great. So, right, as I mentioned before, there's only two ways that an agent may have access to your space. One is a judicial warrant, which John is going to describe. The other is your consent. So agents are allowed to search a non-public area if they are consented to do so. Consent waives the warrant requirement and the probable cause requirement associated with a judicial warrant. Consent must be voluntarily given. It cannot be coerced, and it must be given by an individual with authority over the site to be searched. So we recommend instructing people who may be at the front desk or in the public-facing role to say, I cannot consent to a search. I do not have authority to consent to a search. You need to wait here while I find the right person who can talk to you about what you are searching for.
Perfect. Thank you, Heidi. Let's talk a little bit now about warrants because we referenced it earlier, but we're going to talk about it in a little bit more detail now. Generally, there are two types of warrants that people should be aware of. One is an administrative warrant, and the other is a judicial warrant. We're going to talk about each of those. And the reason why it's really crucial to understand the distinction between the two is that one requires compliance and the other does not. So we want to make sure that we're not doing more than we need to do when we are faced with either an administrative or a judicial warrant. So the first type of warrant we'll talk about is an administrative warrant. This is a document that's signed by an administrative agency, such as the Department of Homeland Security or ICE, Immigration Customs Enforcement. You'll see here where we have it highlighted on the top. It says U.S. Department of Homeland Security. You'll see that it's not signed by a judge. I shouldn't say that. It's not signed by a federal or state judge because it might be signed by an administrative judge. That's why it's really important to look at the heading where this document is actually coming from. In this case, it's the U.S. Department of Homeland Security. You'll see that it's addressed the purpose of this, I should say, is to make an arrest or seizure of someone who is suspected of being in the United States, who is subject to a final order of removal. And you'll see in the top of this example, it says to an immigration officer. So these administrative warrants are addressed to federal immigration officers for execution. They're not addressed to a facility, an employer or a nonprofit organization. They're addressed to the officers. And this is really crucial because if you are faced with an administrative warrant, these warrants do not grant access to non-public or private areas. They don't really carry a lot of weight. And that's really an important distinction to make. Now, I'm going to repeat something that Heidi said earlier, which is that the context, the larger context here is that we have an administration that issued nearly 50 executive orders on day one, and at least 20% of them talk about beefing up enforcement, increasing personnel who can do the enforcement, increasing the locations where enforcement will happen, removal of anyone who's not allowed to be in the United States. So the focus is clearly to round up as many people as possible and deport them. So the agencies are not really likely to go through the steps of getting warrants if that's their goal. If their goal is to round up as many people as possible, they can do that, and the likelihood of them having warrants is not very high, but we want you to be aware of it because it does happen. And that's why I'm just going to ping back to the consent slide, because the way that they're going to get to the people or the things that they want to get to is primarily going to be through consent. So very important to keep in mind that if they do show up with a warrant and it's an administrative warrant, then these warrants don't carry a lot of weight. And that's why we put together the next two slides of what to do during a site visit. So as you're putting your protocol together, you can think about it as, these are the things we can do ahead of time. These are the things that we can do during a site visit. And if we are presented, think of it like a flow chart. If we are presented with an administrative warrant, what do we want the personnel at that facility to do? So if a person is approached by a DHS agent, again, they should refer that agent to the point person or persons listed in the protocol. And that person should remain calm and simply say, I will contact someone who can help you. Agents should be identifiable. They should have a badge. They should have a shirt or a jacket that says on the back of it, ICE or Department of Homeland Security. It may even say police, but they should be easily identifiable. And you are able to request that official's identification information. Now, if the agent shows up and requests access to a non-public area, remember, non-public area they don't have access to without a judicial warrant or consent, then the point person could simply tell that agent, this is a private area. You cannot enter without a judicial warrant signed by a judge. Do you have a judicial warrant? And if the agent doesn't have it, you do not have to grant access to it. If you do grant access, you can't rescind that later. And we'll talk about that because, again, that's considered consent. If an agent asks for information on a specific person, whether it's a guest or a staff member or a visitor or a patient, the point person can, again, reply, I'm sorry, but I cannot give you that information without an appropriate warrant. And the reason why you want to put this in place, and I think if as employers or entities put together these protocols and communicate these protocols with persons who could be present during a raid, I think the message is it's really important to emphasize that we're doing this to protect people. We're not doing this to be non-compliant. We're doing this to protect people. And we want to make sure that an individual doesn't inadvertently give a DHS officer access to a private area. Because again, that can be construed as consent. And if that happens, it's really hard to undo that. So that's the first thing, the first slide we have on what to do during a site visit. In addition to that, individuals really need to be careful not to say or do anything that can be construed as giving consent. And because of that, we're drilling that home. If you can't tell, it's really best to refer that agent to the designated point person. The administrative warrants, like we said, do not authorize a search. They do not authorize ICE to enter a private area. They do not authorize ICE to obtain any information at all. And we put this last bullet here because it's come up in a couple of presentations that we've given in the past. You do not have to say if an individual is on the premises or not. If a ICE agent shows up and says, "Is John Medeiros here?" You do not have to say that, and that he is or he isn't. You do not have to take the agent to the individual named on the administrative warrant. You can simply say, "There's the point person," and the point person can simply say, if you don't have the administrative warrant, we can't help you. You need to come back.
If you don't have a judicial warrant, that's
I'm
what
sorry, if you don't have a judicial warrant. Thank you, Heidi. If you
So
don't have
like, just say, for example, an ICE agent says to me, who is sitting at the front desk of your facility, I see that there's a restroom right down there. I just want to go take a look. And you don't stop them and tell them that they're not allowed to go into the private area, and they wander down the hallway to the restroom or to another waiting area. And there they find a person, then they have been given consent to go to that space and see and hear the things that they hear. And we cannot rescind that consent. So that's why we want to make sure that the people who have control of your space understand these rules. And so now John's going to talk about what a judicial warrant looks like, which we are required to comply with.
Thank you. I would also say in your example, Heidi, which is a really good one, I would say that if an agent says, "I want to go to the bathroom," that's a public, assuming that's a public space, accompany that person to the restroom. I will take you to the restroom and will bring you back. In other words, you're not giving them the opportunity to access spaces that are not public.
So in my example, the restroom was actually not in a public space. It's like the private space that you have to have a reason to go into. So like say you walk into the front lobby of a nonprofit, and back behind the reception area, if you have permission to go in, there's a restroom, but you can only go in there if you have the permission of the person at the front desk. It's not a public restroom. So if the person at the front desk grants permission to the ICE agent to go back into a non-public space, then that is consent.
Thank you. So let's compare the administrative warrant now to the judicial warrant. And I provide you with an example here of what a judicial warrant looks like. A few things to keep in mind. A judicial warrant is an official court document. So this one is issued by the United States District Court. And it says here in the yellow highlighted area, search and seizure warrant. This is an official document that contains the designation of a specific federal or state court and is signed by a judge of that court. You'll see in the lower right-hand corner, there's a space for the judge to sign. The reason why this is so important is because, one, it requires compliance. And two, it's got a much higher bar to obtain a judicial warrant than an administrative warrant does. Because in order to obtain a judicial warrant, the agency, here ICE, or the Department of Homeland Security, must show the court that it has some evidence of probable cause to search the location. So they can't just say, "I want a warrant to go to several places." They have to be able to show evidence that they have reason to believe, a probable cause to show that there's some type of unlawful activity or incident or persons who need to be seized at that particular entity. The judicial warrant has to be signed by a judge, and it has to say the name of the court at the top of the document. During the site visit, so now let's go back to our flow chart, if you will, or our protocol. So we've got things we put in place before the visit. We've got things we put in place during a visit, specifically administrative warrants. The next part of that that protocol would be what to do if an ICE agent shows up with a judicial warrant. So here, the employer is required by law to honor and comply with a judicial warrant. So you have to comply. If the agent has a judicial warrant, the point person should ask for a copy of it, should read it, make a copy of it. If you don't have the ability to make a copy of it, take a photo of it with your phone because you want a record of it. If the agent has a judicial warrant, the employer or the facility entity must allow the agent to enter the non-public area. But there's a huge if here, and it's really important that that your point person or point persons look for this in a judicial warrant. The warrant has to provide sufficient detail of the place to be searched. So, for example, our offices are located at 250 Marquette Avenue South. Okay, if an agent shows up and says this judicial warrant says we get to search 250 Marquette Avenue South, well, there are dozens of offices in this building, so that's not detailed enough to know that the agent is authorized to search our specific office. And so that's an example where the place needs to have sufficient detail. Many of our nonprofit clients are located in buildings with other nonprofits or other solo practitioners, for example. It's really important that the judicial warrant provide detail of the site to be searched. The warrant also has to include the time and scope of the search. It needs to say, on this day, we are going to go to this office to look for this or this person. So in other words, if the judicial warrant authorizes the agency to search a non-public area on Friday or Thursday, March 27th, and they show up on Friday, March 28th, it is completely within that entity's right to say you are outside the scope of the warrant, and you need to come back with a warrant, and you need to come back during the search or during the scope of that warrant. So in other words, this warrant isn't valid because the time that's listed, you're outside of that time. And the warrant, so the warrant has to provide detail of the place. It has to include time and the scope, and the search that's conducted has to be within that place and time and scope. And so it's really the takeaway here is that even with a judicial warrant, it doesn't grant the officer full access to your entire facility. It doesn't do that at any time. So you really want to make sure that if there is a judicial warrant, that it contains enough detail that you know exactly where and when the agent is authorized to conduct the search. And so for that reason, access should be limited to the scope of what's in the warrant, because this is what happens. If they show up on a Thursday and they say, here's our judicial warrant, and the warrant is the time and space limited on that warrant is Wednesday, so they're outside the scope. If you say, okay, here you go, you can't challenge that later because that has just turned into consent. So it's really, really, really important to keep in mind that the scope should be limited to what is listed in the warrant. Heidi, did you have anything you want to add before I move on to the next points in the protocol?
No, nope, I'm ready.
Okay. So now we have what to do beforehand, what to do after, and I'm sorry, what to do beforehand, what to do during in the event of an administrative warrant, and also what to do during in the event of a judicial warrant. And we talked a little bit about the initial contact person, and we talked a little bit about the point persons. So then we wanted to just acknowledge that there are other people who could be present during a protocol. So during a site visit. So we wanted to make sure that the protocol that you put together includes information on what everyone can do, whether they're part of the initial, whether they're approached by the agent or they're not the point person. We just want to make sure that people know what they can do during the protocol. Obviously, one is to stay calm. You can have people videotape, record the agents at the workplace or at the facility. You could request facilities save any company surveillance footage that may be available during the site visit. These are all things that, well, let me just finish this one. If the ICE agent arrests someone, you could ask the ICE agent where they're being taken. And that information will help lawyers in the future find the person who may have been taken away. The takeaway here, and there's one more slide, and I'm sorry, Heidi, I think you were going to do this slide, and I jumped in, so I'll let you do the next one. But the one thing I do want to say here is that the reason why the protocol should include steps after the site visit is because if the agent obtains information in a way that is not through consent or through a judicial warrant, then the facility or the individual even can challenge that in court in the future. They can challenge this is a violation of that Fourth Amendment, that slide that we showed you earlier on in the presentation. This is a violation because it wasn't done properly. And that's why we want folks to record this. That's why we want to try to get as much information as possible, because even if they seize information or someone in a way that shouldn't happen, you can challenge it later as an illegal search or an illegal seizure because they didn't follow the proper protocols. And so our last slide will be this one.
And then we will answer all of your excellent questions that are in the chat. So immediately following a site visit, we recommend that your protocol say things like this: write or record how many ICE agents were present inside and outside of your facility, how they were dressed, whether they were armed, and if so, how. If the agents made you or other people who were with you believe that you could not move or leave, were you made to feel as though you were coerced to stay in a place, or were people free to move around? And did the agents mistreat anyone, including by raising voices or being threatening? And if so, how? So we should record these things to the best that we can. And then the organization should seek legal counsel after the ICE raid just to get follow-up advice related to any risks that can be mitigated, either for the organization, the people served by the organization, or the employees of the organization. So that is the end of our formal presentation. I've been taking notes on your comments and I have them grouped into categories. So I want to start out with just a couple that are really, really good, sort of fundamental. Did we follow along with what we were trying to teach you today? So I want to start with a question about whether the information we provided today of protection for staff and guests and visitors also applies to clients. So the person said, we provide inpatient treatment services. We provide services to residents of an apartment building. How do we respond if ICE is asking about someone who is in a treatment program or who lives at one of our programs? And the answer is that you would only provide information if you had a judicial warrant. And in the case of HIPAA protected private information, you would need to follow HIPAA law also, which would require a judicial warrant in order to disclose protected health information. But just like, you know, a nonprofit that doesn't have protected health information, you wouldn't provide any information voluntarily about your patients or people you provide services to without a signed judicial warrant. So that's what we're looking for here, is a signed judicial warrant. And that would be along the lines of what John described as a judicial warrant. So go ahead, John.
I'll just add that we thought about having this slide in here on HIPAA and
HIPAA.
protected information. So thank you for raising that question. We debated whether or not we should have it or not, and we didn't want to make assumptions that we would have healthcare providers online, but at the same time, now we know.
Yeah. So here, John, is one for you. And I think this is also like a really fundamental understanding question. Are judges required to sign a judicial warrant for persons who are subject to removal proceedings? So like, do you have to have a signed judicial warrant in order to detain or remove someone? And it goes along with another question, which is, can an ICE agent remove someone from a public area without a warrant? So could you take those two? Do you have to
Sure,
have
I'll
a
start
judicial
with
warrant
the
to remove
first one.
someone?
Could an ICE agent remove someone from a public area without a warrant? The answer is yes. In fact, what often happened, excuse me, before the rescission of the sensitive locations policy, what agents would do is sort of wait on the sidewalk outside of hospitals or wait on the sidewalk outside of churches. And then once the individual is on the sidewalk, which is a public space, they would then arrest that person. Now, typically, it would involve an administrative warrant because the agent is being asked by the administrative agency to go after this person. So it's not a roundup in the same way that it's a raid. It tends to be more focused. And we know this person is there and this person is listed on this administrative warrant. This person is subject to removal, so we will get them. And so that's the answer to the second question, removal from public areas. The first question, I want to make sure that I understood it correctly. Is a judge required to sign a judicial warrant for someone who is subject to removal? Was that the question?
Yes, that's exactly the question.
Okay, I thought so because if someone is subject to removal, they're more likely to have an administrative warrant, just like we just mentioned, the person on the sidewalk outside the church. A judge is not required. A judge is required to sign a judicial warrant only if the government, DHS, has met its burden of establishing that it has probable cause to believe that there's someone or something that's unauthorized in that location. So provided that the government presents enough evidence, the judge should sign that warrant. The judge wouldn't, a judicial warrant. A judge is not likely to sign a judicial warrant if the agency hasn't met its burden of establishing proof.
So I guess the takeaway for me here is that, you know, ICE agents can arrest someone without a judicial warrant. That's mostly how they're going to do this. They might have an administrative warrant. They might have no warrant. The point is that they cannot get into your private space to do this without a judicial warrant. Otherwise, they can certainly arrest people in the public without a judicial warrant. So the next little subset of questions is about renters. And I have been asked this question a lot. So if you are a nonprofit renting a space within another entity, who makes the decisions about how to respond in an ICE raid visit? And the answer is that it is the party that controls access to the space. So if you're a nonprofit that is providing a nonprofit activity within a school district building after school, your activity is subject to the rules of the school district and should follow those. On the other hand, if you are renting space from a landlord and you have the sole right to occupy your suite in that landlord's space, you have the right to control what happens and what policies and procedures you follow within the suite that you have control over. So the answer is, who has the right to control the entrance to the space? If you're an activity providing after school services in a school, it's the school. If you have the right to use a suite and you have a lease that says that you have the right to use it, then you will be able to control how you interact with ICE agents within the space that you have control over. Do you agree, John?
I do. It also goes back to that definition let me see if I can find it real quick, but the definition of the difference between public and private spaces, it's really about the expectation of privacy and who has that expectation of privacy. So I do agree with your assessment.
Okay, so there's a lot of questions, John, in the chat about ICE agents and like things about them. And they range from like, can ICE agents deputize local agents in like rural communities? Can ICE deputize people who aren't ICE agents to act as ICE agents? What are they likely to act like? Do they hire contractors? those kinds of questions, John. What do you
Yeah,
think they're gonna act like, and
yeah,
can they hire private people to do their work?
we have um we have some savvy people online today. Um,
Yes.
one of the executive orders, in fact, I think two of the executive orders that were signed on January 20th talk about this specifically, about deputizing local law enforcement to carry out federal immigration laws. Because even though Minneapolis and St. Paul have separation ordinances where they say they won't do it, there's nothing really to prevent a Minneapolis or St. Paul officer from saying, well, I want to do it and I'm going to do it. And so, but your question was specifically to rural communities, I believe I heard you say. That's where it happens more often, where um, where ICE agents will deputize local enforcement to carry out federal immigration laws. And so there is a push to do that, so they can do that. I will also say that I don't know if they will hire outside contractors to do that. And I say that because they're even though this administration is slashing federal jobs left and right every day, they're not slashing the enforcement folks. In fact, they're moving folks. Remember I said earlier, there's a part of the Department of Homeland Security that's called the Immigration and Customs Enforcement. There's a part called the USCIS, the Citizenship and Immigration Services. That's the adjudicatory arm of the Department of Homeland Security. And there's the Customs and Border Protection. They're shifting CIS agents over to enforcement. So I don't think that and they also just passed a bill that will allow millions and millions of dollars to hire more ICE agents. So I don't think that they're likely to contract outside folks. I think they're going to hire a lot more. And so they can deputize local law enforcement and they can hire a lot more. Uh, Minnesota there was a bill that was introduced in the Minnesota State Legislature that would address this problem, this issue, which would remove the sanctuary location or the separation ordinances from Minneapolis and St. Paul. They would make separation ordinances illegal, basically. And one of the arguments that I actually wrote to my state legislator about this, but one of the arguments against that is that ICE officers have to go through a very intensive training. And that training is weeks and weeks and weeks and weeks and weeks long. They have to understand immigration laws. They have to understand the nuances of immigration laws. And immigration law is very complicated. It's reported to be more complicated than tax law. And so to deputize local enforcement to carry out federal immigration enforcement activities, it runs the risk of this being done by folks who don't know what the law is. And it also shifts those folks are no longer able to address the local laws that need to be enforced because they're going to be spending their time enforcing federal laws without even understanding what those federal laws are. And so, yes, they can deputize. There's executive orders that really push for deputizing. There's more money being shifted to ICE to hire more agents. But even with the deputizing, there's still problems because they're not going to be sufficiently trained to understand the nuances of the federal laws.
There's a lot of questions about illegal ICE activity, like how can someone who has the legal right to be in the US be detained and arrested by ICE agents? But I think, and I'm not sure if you have a quick comment on that, John.
I will say that I have a letter that's going to be printed in the St. Paul Pioneer Press on Sunday about this, very much related to this, in that there are folks who are here because unlawfully because they entered without inspection. There are folks who are here unlawfully because they entered with inspection, but they overstayed. And then there are folks who are here lawfully. And the problem is officers can't always tell the difference, especially if they're deputized. So they'll just round up people and then say, oops, sorry, if that person is actually in the United States lawfully. One of the things that this administration is doing, which is unlike any other administration, is though that there are 500,000 people who entered lawfully through various parole programs. They had sponsors in the U.S. They were given permission by the U.S. government to come to the U.S. They have requested work authorization, which they're allowed to do while they've been here. They've not committed any crimes before they got here. They've not committed any crimes since they've been here. They've been properly vetted, and they're allowed to be here. And the administration just announced last Friday that they're going to remove their authorization to be in the United States effective April 25th. And so we are now creating undocumented people and then removing them, saying we're removing these illegal aliens. That's not exactly what the promise was. You know, that's not exactly the same thing as identifying people who are in the United States unlawfully and ensuring their departure by enforcing removal proceedings. And so it's a good question. How can they do this illegal activity? In many cases, they can't, which is exactly why a lot of courts are saying you can't do that. And so we keep our eye on the courts right now because that's really where the checks and balances lie.
Yeah, for sure. So there's just a couple technical questions that I thought I would buzz through. One of them is, can an outdoor space be considered non-public? For example, if we're using a football field that we have paid to use, can that space be considered non-public? Yes, I mean, if people who are not allowed to be there can't enter, like for example, there's a gate, or if someone were to come from the public into the space and they had to have a reason to be there and there was someone guarding that, then it could be considered non-public. It would be harder to enforce, for sure.
Much harder, because if you're talking about a ball game, you're going to have people watching the game, right, who are probably not invited. But in other words, they probably don't need permission to be there to watch the game. And that's where it gets very gray.
Yeah. The next one is about multiple or separate non-public areas within the same building. You would have to give consent to enter each separate non-public area. So if you allow an ICE agent consent to go into one non-public area, and anything they can find from there, they would have consent to go into. But if it was a different entryway, they would need different consent to go into a different non-public space. The last question I'd really love you to answer, John, is, can someone be arrested for protecting or assisting someone in escaping detention from ICE? This is the last question we'll take.
That's a hard one. It's a hard one because so this presentation today is really half of a larger presentation that I've given mainly to congregations, churches and synagogues and mosques in the area. And because that presentation, the first half of that presentation looks at what's considered a violation under the anti-harboring statute of the Immigration and Nationality Act. This presentation is not that. This presentation is more about what constitutes a legal search. What your question invokes is liability under the anti-harboring provision. So it's a lot more complicated. I will say two things, and hopefully I'll answer your question. One is that in the reason why it's so hard is because harboring is defined differently in different parts of the country. In the Eighth Circuit, so for example, a question that comes up a lot is, if I house someone in my church and they're not authorized to be in the United States, am I violating the anti-harboring provisions of the Act? And the Eighth Circuit hasn't, which is where we are, hasn't really made that decision. Other circuits have decided that in most cases, and I think this is a good sort of default to think about, in most cases, there has to be some kind of intent to conceal the individual from the authorities. So in other words, it can't just be providing the housing, it has to be intending to prevent their detection from the agencies. And a similar question that comes up is transportation. Am I able to transport someone to a doctor appointment or to school or to a ball game, or am I violating the anti-transporting provisions? And that there's more guidance in that. In that the transporting has to be to be found in violation, the transporting has to be in furtherance of their unlawful presence in the United States. So taking them to appointments would be okay. Taking them out the back door because an ICE agent shows up is probably not the same thing. And that's to trigger the anti-transporting provisions of the Act.
So this isn't legal advice on those acts, and you shouldn't rely on this presentation.
Correct.
We want to thank you all for joining us. I have a 3 o'clock. I'm sure many of you do too. Thank you for being with us today. Thanks for listening along and for your excellent questions. And thank you to the Minnesota Council of Nonprofits for hosting us.
Yes, thank you very much.